Today we are here to discuss uh, about the Advocate on Record Examination 2024. So in this examination, basically we all know that there are four papers, four subjects. First is practice and procedure. Second is professional ethics and advocacy. Third is drafting, and fourth is leading cases. Each paper consists, each paper carries 100 marks, and the duration for each paper is about 3 hours. So today we will discuss about practice and procedure, the first paper. First, we need to understand about the advocate on record system and advocate on record examination. Why there is necessity of the advocate on records? This question, because when we deal with advocate on record, then we have three type of advocates. First is advocate, second is advocate on record, and third is senior advocate. So why this system of advocate on record? In Supreme Court, what happens that there are many advocates who practice from all across India. Some from Tamil Nadu, some from Kerala. So there has to be some accountability. So if any lawyer is allowed to just come here and file wakalatnama, then the accountability would be like there would be problem. So the first thing is accountability, and the second thing is quality, because certain standards has to be maintained while practicing in Supreme Court. So as we all know that this for appearing in advocate on record examination, you need to have 4 years of experience, and thereafter you'll have to take the completion certificate of 1 year. Then only you can appear in the advocate on record examination. So how this examination come into play? If we see Article 145 of the Constitution of India, the Parliament, the Constitution has provided the powers to Supreme Court to frame its own rules. And accordingly, Supreme Court has framed its own rules, which is called Supreme Court rules. Earlier, as I remember, there was Supreme Court rules 1966, and thereafter the Supreme Court rules 2013. So as per Supreme Court rules, this examination is conducted. This Supreme Court rules have been framed, as I said, has been framed by virtue of Article 145 of the Constitution of India. When we appear for the advocate on record examination, particularly practice and procedure, then we should know the jurisdiction of the Supreme Court. The jurisdiction of the Supreme Court, according to the jurisdiction provided to the Supreme Court, is threefold. First is original jurisdiction, second is appellate jurisdiction, and third is advisory jurisdiction. But apart from that, the Constitution, Article 137 of the Constitution, has provided a review jurisdiction to Supreme Court to review its own orders and judgments. And thereafter, there is a jurisdiction which Supreme Court has created for itself, which we call curative jurisdiction. This jurisdiction has Supreme Court has created for itself by virtue of Order 47 of the Supreme Court rules. So when we talk about the jurisdiction of Supreme Court, the original jurisdiction consists there are constitutional provisions such as Article 32 of the Constitution of India, thereafter Article 71 of the Constitution of India, thereafter Article 131, Article 139A1, and 2 of the Constitution of India. Apart from that, Section 25 of CPC and Section 406 of CRPC provides original jurisdiction to the Supreme Court. Appellate jurisdiction, the Constitution provides Article 132, Article 133, Article 134, and Article 136 of the Constitution of India, where appellate jurisdiction has been provided to the Supreme Court. Apart from that, there is some statutory jurisdiction which has been given to the Supreme Court, like Supreme Court Enlargement of Criminal Appellate Jurisdiction 1970. This is, if you read with Section 379 of CRPC. Apart from that, we can file statutory appeals like Section 62 of IPC, Section 23 of the Consumer Protection Act, Section 38 of the Advocates Act, Section 116 of the Representations of the People's Act, Section 22 of the NGT Act, Section 130T of the Customs Act, and so on. So there are jurisdiction which has been appellate jurisdiction which has been provided to the Supreme Court by virtue of statute, by virtue of different statutes. And as I said, Supreme Court is having the exclusive jurisdiction of advisory jurisdiction. This is provided under Article 143, 1 and 2 of the Constitution of India. And as I said, review jurisdiction and curative jurisdiction. So we'll deal with the original jurisdiction and the appellate jurisdiction in our first lecture series. If we talk about the original jurisdiction of the Supreme Court, we should first see Article 32 of the Constitution of India. Article 32 of the Constitution of India is says remedies for enforcement of rights conferred by this part. The first important thing is that this Article 32 is in our part 3 of the Constitution of India. It means that Article 32 of the Constitution is one of our fundamental rights. When we want to invoke the Article 32 of the Constitution of India, then there has to be infringement of fundamental rights. If we read Article 32(1), it specifically says that right to move Supreme Court by appropriate proceedings for enforcement of the rights suffered by this part is guaranteed. So 32 guarantees the right against violation of your fundamental rights. And Article 32(2) is very important, where Supreme Court has been given powers, has been given power to issue certain directions, orders, or writs, including the writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, and circulary. So when we talk about Article 32 of the Constitution of India, so Article 32(2) says that Supreme Court can pass certain orders and directions and writs in the nature of all those writs. So normally questions are asked as to what is difference between Article 32 of the Constitution of India and Article 226 of the Constitution of India. So we'll have to answer this thing because Article 32 has been, this is a right where you can directly file a writ petition before Supreme Court when there is infringement of fundamental right. Article 226 is broader, where you approach High Court for violation of your fundamental rights as well as other judicial rights also. The only thing is that the other parties should be stayed within the meaning of Article 12 of the Constitution of India. Now, there are certain risks. Sometimes the questions are asked as to what is the meaning of habeas corpus, what is the meaning of mandamus, and other writs. So, as we all know, habeas corpus, the literal meaning of habeas corpus, corpus means body, as to present the body. So, when there is illegal detention, in that case, a writ of habeas corpus can be filed. Second is mandamus. Mandamus is a command whereby you give a command to certain person, certain authority to do certain things or omit to do certain things. So in that case, when the court passes a command, it passes the order or writs in the nature of mandamus. Now, prohibition is something which applies when a forum, a judicial forum or other forum, statutory body, which is like functioning, the power has not been given and it is functioning beyond the powers. Like if a matter is pending before a chief judicial magistrate and the chief judicial magistrate is trying a sessions case and proceedings with the sessions case, in that case a writ of prohibition can be filed. So to prohibit, don't proceed because you don't have the power, you don't have the authority, you are acting beyond your jurisdiction. In that case this writ of prohibition is issued, and thereafter a writ of quo warranto. Quo warranto, as it means by what authority, by it means that a person, a public person who is having no authority is proceeding with the matter. Or like the famous case is B.R. Kapoor case, where the chief ministership of Jayalalitha was challenged, and it was said that she is no more MLA and she is holding that post illegality. In that case, this writ of quo warranto was issued as to that post, the public post was held illegally. So this is a writ, in that case, a writ of quo warranto is issued. Now, thereafter, certiorari is by what authority? Like if something illegality is being done, in that case, court issues certain types of writs and set aside that order. So when we ask for setting aside of any order, in that case, we ask for a writ of certiorari. And there is one important direction which is invented in PJ Thomas case. In that case, the selection of the appointment of Mr. PJ Thomas was challenged, and a writ of quo warranto was asked as to it was submitted that a public post is being held by a person who has got no authority, but Supreme Court did not agreed with that contention, and a writ of declaration was issued. So when these all writs, like when I said habeas corpus, mandamus, prohibition, quo warranto, certiorari, apart from that, an order of declaration was issued in that case. Now, normally questions are asked about Article 32. There are certain cases which, in my view, is very important when we go through Article 32 of the Constitution of India. One is Romesh Thapar. This is 1950 decision, where the Honorable Supreme Court said that this Article 32 uh, guarantees a right to a person that he can move before Supreme Court in case there is any violation of fundamental right. And Supreme Court, the contention from the other side, it was taken that this person is directly coming before Supreme Court even without availing any remedy before High Court, because in that case he could have been well gone before High Court for asking the relief, and he has directly come to Supreme Court. But Supreme Court dispelled that contention and said that when there is a violation of fundamental right, in that case, one can directly come to Supreme Court. And there are many instances where the Honorable Supreme Court has directly entertained such petitions, even in cases where the person has not availed its remedy or exhausted its remedy before High Court. This Rome's Thapar was followed in many cases, but then there is a judgment of the Honorable Supreme Court when this contention that whether a person can directly come to Supreme Court or not. So, in that Supreme Court did not deny, like it's not that you can't come to Supreme Court. You can come to Supreme Court, but it said that first you should try to go before High Court and try to and exhaust this High Court proceeding, and then you can come to Supreme Court. PN Kumar versus, this is the case which is PN Kumar versus Municipal Corporation of Delhi. This is the 1987 decision where the Supreme Court said that because if we entertain all such cases where there is direct violation of fundamental right, and when person directly comes to Supreme Court, in that case, Supreme Court would be flooded with many cases, and the whole edifice will crumble. So Supreme Court said that first, in those cases also, because because Article 226 is very broad. In that case, one should first go to High Court, exhaust its remedy, and then if he is not satisfied, in that case, he should come to Supreme Court. Supreme Court also said that it's not that High Court have not good judges. He said that High Court has got good judges, excellent judges, and then it is also better for the litigant to approach the nearest court rather directly coming to the Supreme Court of India. So, when you are asked to write about Article 32, and when you are asked, though Article 32 is part of the Constitution of India, and as we know that when Mr. B.R. Ambedkar, he was asked about the the article about the provision of the Constitution, which is very close, very dear to him. He said that, in his opinion, Article 32 of the Constitution uh, is the very soul of the Constitution, and he is very happy that the Constituent Assembly has accepted it as a fundamental right, where the right to directly come to Supreme Court, where the right to approach the Supreme Court in case of violation of fundamental right is guaranteed. So then what happened? What happens that earlier? What happened that in many cases, Article 32 petition was filed against the judgments of the High Courts also. So, and not only judgments of High Court, in many cases, Article 32 was filed against the judgment of Supreme Court also. So, there is a judgment. I think this is 7 judges bench judgment. Naresh Sridhar Mirajkar. This judgment is of 1966. I think this is a very important judgment, and one must know about this judgment. This judgment says that you cannot file Article 32 against an order or judgment of a constitutional court. So it barred, like against the judgment of High Court, or against the judgment or order or decree of Supreme Court, whatever, this remedy of 32 is not there. So Ramesh Vidar Mirajkar has stated in clear terms. But then thereafter, in AR Antule, what happened that a constitution bench judgment of 5 judges uh, gave its verdict that A.R. Antule, who was earlier Chief Minister of Maharashtra, he should be tried before High Court. So the trial proceedings after this order, the charges were framed by High Court, and Mr. Antule challenged that order before Supreme Court. The order of High Court, where charges were framed, it was challenged by A.R. Antule before the Honorable Supreme Court. Now the question before Supreme Court, and that too under Article 32. So now the question before Supreme Court was the earlier judgment also, where a five-judge bench has said that you go High Court and trial would take place in High Court. Supreme Court, exercising its power under Article 32, set aside its own earlier order passed by five judges bench of the Supreme Court. And the concept of ex debitio justitia means for justice, it is being done. Like it should not be like you can't entertain 32 against an order of Supreme Court or High Court, but for doing justice in the matter, this order was, and seven judges bench set aside the earlier order and said that uh, the the person should be given a right to appeal, because if the matter is directly tried in High Court, then he will lose a right of appeal to come before Supreme Court. So after that, when this question was going on as to like what if the order of the Supreme Court is bad, and what if it is dismissed in review also, then what will happen? In that cases also, in many cases, after dismissal of review, Article 32 was filed. So thereafter, there is a judgment of Supreme Court, which is Rupa Ashok Hurra. In that case, Supreme Court, I would say, all respect, invented a new jurisdiction of curative jurisdiction. In that case, said Supreme Court held that one can file a curative petition before Supreme Court. But in that case, Supreme Court held that the the requisites are first that your review petition should be like needs like when it is dismissed by way of circulation, then only you can file curative petition. For filing curative petition, you need to have a certificate from a senior advocate. Then only you can file a curative petition. Apart from that, there are only two grounds on which you can file a curative petition. The first ground is violation of principles of natural justice, in the sense that Supreme Court has passed an order where you were not a party and that order adversely affects you. And second is bias, that the judge was connected with some matter and there was some apparent bias, and therefore this order was passed. So first, as I said, requisite is certificate. The first requisite is that order of review dismissed in circulation. Second, then in that case, you need a certificate, and the grounds are two: violation of principles of natural justice and bias. And the curative petition goes before the four judges, the judges who pass the order, and the senior most three judges or two judges, whatever. So this is the composition of the curative petition. And so far as I remember, to my memory, there is a case wherein curative was allowed, and that case is Sugar Singh. So if you write about that case, it would be very good. In that case, yes, sugar thing case. So in that case, what happened that High Court had out of 8%, High Court had acquitted 8 persons and convicted 4 persons. That order was challenged before Supreme Court, and the High Court had reversed the acquittal of those persons even without hearing them. So Supreme Court said, yes, we have done some mistake, and but nothing to worry. We will rectify our mistake. And Supreme Court was magnanimous enough to rectify its mistake. There are certain instances in Juvenile Justice Act also where even after dismissal of your SLP, you can file petitions before Supreme Court and say that that juvenility has not been decided. So there are certain decisions on that aspect also. I will try to cover that also. But before that, we were discussing about the original jurisdiction of the Supreme Court. There are Article 32 petitions where Supreme Court has entertained suo motu also. Now, when you see the Supreme Court rules, this is Order 38, Rule 12. There is a provision for there is a provision for public interest litigation. Because in public interest litigation, earlier there are so many instances where the Honorable Supreme Court has entertained a letter also and treated it as a PIL and has passed many orders. Just one second. Yes. So there are instances like a letter written by Sunil Batra against about the inhuman treatment in jail was entertained by Supreme Court as public interest litigation and orders were passed. Certain other examples are Bandhua Mukti Morcha and other cases also. But then thereafter there was flooding of public interest litigation before Supreme Court also and before High Court also. Before High Court, PILs were being filed under Article 226 of the Constitution of India and obviously under Article 32 before the Honorable Supreme Court of India. So in many cases, Supreme Court has said that this is a publicity interest litigation and motivated litigation and all those things. So Supreme Court in its rules 30 order 30 38 rule 12 has laid down certain conditions prior to filing public interest litigation. Rule says that Supreme Court suo motu can also like entertain any any letter, any petition as public interest litigation. And apart from that, just want to yes. And yes, and apart from that, Supreme Court has laid down certain conditions like what is your locus as to how you are like filing this PIL, what is your relation, and about the credibility also. So now a person has to satisfy Supreme Court about its locus and credibility also. Then if we move to the original jurisdiction, the next original jurisdiction is Article 71 of the Constitution of India. This is also an exclusive jurisdiction given to Supreme Court to decide the dispute with regard to presidential and vice presidential elections. No other court has been given this power to decide the election of the president and vice president. There is a while exercising this jurisdiction, while filing this petition, we need to see the act involved in it, which is Presidential and Vice Presidential Act 1952, and it has to be read along with Order 46 of Supreme Court Rules 2013. So there are certain prerequisites before filing any such petition about a matter relating to the presidential and vice presidential election. The rule says that there has to be a court fee of a stamp fee of rupees 20,000. Then there are other certain conditions like Order 46, Rule 7 says you can file an election petition only in case 20 or more electorate join together. That is a prerequisite, and the other requisites are a certificate by senior advocate, and there is security deposit of 50,000 while filing this petition. There are many petitions earlier which have been filed before the Supreme Court. There are cases filed by Mr. Charan Lal Sahu versus Fakhruddin Ali Ahmed, uh, then N. Sanjeeva Reddy, Gyani Jail Singh, KR Menon, etc. So most of the cases, all these election petitions were dismissed. So I would insist that when you see Article 71, you must also see Order 46 of the Supreme Court Rules 2013, which speaks about the conditions when you can file this petition. The other original jurisdiction, as I said, this is also an exclusive jurisdiction to Supreme Court, Article 71. The other jurisdiction is Article 131 of the Constitution of India. Article 131 of the Constitution of India provides a jurisdiction to the Supreme Court where this is, if you read this article, this is very important. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. Therefore, this is an exclusive jurisdiction provided to Supreme Court between Government of India and one or more states. B, between Government of India and any state or states of on one side and one or more other states on the other side. Between two or more states. So the dispute has to be between, the Supreme Court will exercise its jurisdiction only when there is a dispute between Government of India and one or more states, between Government of India and any state together with one side, with other states, or between two or more states. And thereafter, the words are very important. If and in so far as the dispute involves any question, whether of law or fact, on which the existence or extent of legal right depends. So this jurisdiction can be exercised in case of such disputes, and the dispute may be a question of law or a question of fact. But the important thing is that there has to be existence or extent of a legal right. So if you don't have, if the state has, if the dispute does not involve any question relating to legal rights, then Supreme Court cannot exercise its jurisdiction. Supreme Court refused to exercise its jurisdiction. So these are the requisites. Now, a question was asked before Supreme Court as to what is the meaning of state. When we talk about between government of India and one state or between states, so whether the state which is defined under Article 12 of the Constitution of India would also fall within the definition of state or within the purview of Article 1 for invoking the jurisdiction of Article 131. The Supreme Court repelled this contention and said that no, state has to be strictly state, not an state under Article 12 of the Constitution of India. So, any public sector undertaking or any other authority which is not a state or which is only a state under Article 12 of the Constitution of India, they cannot invoke the jurisdiction of Article 131 of the Constitution of India. The other aspect is that in case of any dispute with regard to in water, interstate river, in that case, the Constitution has provided Article 32, and in that case, Article 30, Article 262, and in that case, Article 262 would be invoked to decide that jurisdiction. So sometimes questions are asked about the dispute between two states in case of relating to the adjudication of dispute relating to water of interstate rivers or river valleys. So we must see Article 262 of the Constitution of India, which says disputes relating to waters, adjudication of disputes relating to waters of interstate rivers or river valleys. Parliament may by law provide for adjudication of any dispute or complaint with respect to the use, distribution, or control of waters of or in any interstate river or river valley. Notwithstanding anything in this constitution, Parliament may by law provide that neither the Supreme Court, this is very important, 262.2 bars the Supreme Court, notwithstanding, it starts with non-obstante clause, notwithstanding anything in this constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as is referred to in clause 1. So, and uh, and and uh, uh, and there is for adjudication of uh, disputes relating to water, the water tribunal has been constituted, and all those matters where there is dispute with regard between two states with regard to interstate rivers, so they first approach before the tribunal for that instance. Now, there are few judgments in that with regard to Article 131 of the Constitution of India. The first case is State of Karnataka versus Union of India. This is a 1997 decision, 1997, 4 SCC 608. In that case, Supreme Court says that the jurisdiction of Article 131 of the Constitution of India are not strictly in the nature of suit as defined under CPC. So it is not guided by CPC, as it is not confined to the contours of CPC. And this decision was held by majority of 4-3, and where suit was found to be maintainable, wherein the state had filed a suit against constituting a commission of inquiry by union against state. In this case, an inquiry was a commission, the inquiry commission was constituted by central government, and state had challenged this, stating that this is a violation of federal structure of the constitution, and center has got no such power to constitute a commission of inquiry. So this matter was entertained by the Honorable Supreme Court under Article 131 of the Constitution of India, and said that CPC is not binding on us, and that it is the suit is maintainable. So strictly it is not a suit in case of CPC, and also it's not that it can't be invoked in when we say that some criminality is involved in that case also. So it is not in strict sense civil or criminal or guided by CPC. When we said that about whether state within the meaning of Article 12 of the Constitution of India can file a case. So for that, I just want to give that reference. This is State of Bihar versus Union of India. This is 1970 decision, 1971 SCC 67, and wherein it has been held that the enlarged definition of state would not lie for a suit under Article 131 of the Constitution of India. Apart from that, the other original jurisdiction of the Supreme Court has, has been provided by the Constitution. The Constitution has provided Article 139A1 and Article 139A2. So, in my view, this is very, very important. So why this article is has been placed by the has been placed in our constitution is because there has to be some uniformity. Sometimes what happens that the same issue, like a case relating to the same issue, is pending, like is filed before Delhi High Court. Same issue is filed before Bombay High Court, Allahabad High Court, Patna High Court, and other High Court. So it may be cases where the same issue is pending before different High Courts, and there may be divergent of opinion. There may not be uniformity also. So in that case, Supreme Court has been given power, like to withdraw all those cases to itself and decide it. So I think I should read Article 139A 1 of the Constitution of India, which says transfer of certain cases where cases involving the same or substantially the same question of law are pending before the Supreme Court and one or more high courts, or before two or more high courts, and the Supreme Court is satisfied on its own motion. Like, even without any application, if Supreme Court is satisfied on its own motion or an application made by Attorney General of India or by a party to any such case, that such questions are substantial questions of general importance, the Supreme Court may withdraw the cases or cases pending before the High Court or the High Courts and dispose of all the cases itself. So the requisite conditions. So we have seen that Supreme Court can exercise its jurisdiction on its own motion or by an application by Attorney General or by a party to such case. The important aspect are that such questions should be substantial questions of general importance. Then only Supreme Court can exercise its jurisdiction, and in that case, Supreme Court may so that there may not be divergent of opinion or judgments or confrontation in that case, and also saving of time. In that case, Supreme Court may withdraw the cases or cases pending before the High Court and dispose of itself. After, there is a provision also, which in my view is very important, provided that the Supreme Court may, after determining the said question of law, return any case so withdrawn together with a copy of its judgment on such question to High Court from which the case has been withdrawn, and the High Court shall, on receipt thereof, proceed to dispose of the case in conformity with such judgment. Like what happens that the issue is same, the same question of law of general importance is pending before different high courts, but facts may be different. So it would be a very lengthy task sometimes for Supreme Court to pass its judgment according to each fact. So in that case, what happens by exercising its jurisdiction, Article 139A(1) of the Constitution of India, it withdraws the cases, all cases from High Court to itself, decides the question of law, and then passes the matter to the High Court, remands the matter to High Court to decide it as per its decision. What has been answered, the judgment given by the Supreme Court, it has to be decided in accordance with that. And two, 139A(2) is the Supreme Court may, if it deems it expedient to do so for the ends of justice, transfer any case, appeal, or other proceedings pending before any High Court to any other High Court. So 139A(1) says withdraw to itself, decide it, send back. And 139A(2) is like in such cases, like cases are pending before different high courts. So in that case, Supreme Court may pass an order under Article 139A(2) that all the cases from different high courts be transferred to one high court. Like cases are pending in Bombay High Court, Allahabad High Court, Supreme Court, Madras High Court. Supreme Court can pass an order, may pass an order that all those cases in different high courts be transferred to the High Court of Delhi. So this is the original jurisdiction of the Supreme Court, which has been provided by the Constitution of India. Apart from that, there are certain other original jurisdiction which is exercised by the Supreme Court. We should know about the jurisdiction. One is Section 25 CPC provides original jurisdiction to transfer civil cases. So there are many transfer cases which are filed before Supreme Court, particularly in civil cases, particularly in matrimonial matters, where a case has been filed in a district court or in a high court of different state, and the wife is staying in the jurisdiction of some other high court. In that case, a petition under Section 25 of CPC is filed for transferring the case in the ends of justice. And Supreme Court exercise, normally we have seen that in such cases, considering the difficulty faced uh, by the person, Supreme Court normally transfer the cases. So nowadays, Supreme Court permits also the other side to appear virtually. And for criminal matters, the Supreme Court exercises its jurisdiction under Article 406 of CRPC. When we talk about transfer of cases under Section 25 and under Section 406 of the Supreme Court, you will find that Supreme Court is more liberal in transferring cases under Section 25 of CPC. Means that Supreme Court is more liberal in transferring the civil matters rather in criminal matters. Because what happens, there are certain difficulties in criminal matters. Suppose FIR has been lodged in some state, in some district, and then after lodging of the FIR, there would be investigation by police, and then witnesses would have to be examined. So in those cases, Supreme Court finds it difficult to transfer such cases because it would be difficult for the investigating agency. It would be difficult for the witnesses also to depose. So normally, Supreme Court does uh, does not want to or does not uh, uh, interfere or passes an order for transfer under Section 406. But there are cases, there are many instances where Supreme Court has transferred criminal cases also, like when there is a threat to the witness, when there is no chances of fair trial. In that case, Supreme Court. So I remember one judgment of Justice Panchal. It is Vikas Kumar or Vikas Singh Rurkewal. I would try to provide that citation also. In that case, Supreme Court let down as to the difficulties in transferring the cases. But Supreme Court said that when there are chances of miscarriage of justice, or there are chances of there are chances that fair trial uh, would not be done. In that case, Supreme Court has exercised its jurisdiction to transfer the cases. So, in my view, I think I have covered so far as the original jurisdiction of the Supreme Court is concerned. As I said, that Constitution provides Article 32, 71, 131, and 139A and 2 of the Constitution, and apart from that, Section 25 and 406. So normally questions are repeatedly asked about the original jurisdiction of the Supreme Court also. The other jurisdiction of the Supreme Court is the other jurisdiction of the Supreme Court are appellate jurisdiction. Now, this appellate jurisdiction, when we see the appellate jurisdiction, the Constitution has given the appellate powers to the Supreme Court by virtue of Article 132, Article 133, Article 134, and Article 136 of the Constitution of India. These articles are very important because in AOR examination, repeatedly questions are asked about the appellate jurisdiction of the Supreme Court provided by the Constitution. We need to study. We need to read these articles, and there are differences between Article 132, 133, and 134, and obviously Article 136, where most of the cases are filed under Article 136. So if we see Article 132 of the Constitution of India, it says appellate jurisdiction of Supreme Court in appeals from High Court in certain cases. Yes. So this jurisdiction has been given to Supreme Court in appeal from High Court in certain cases. Means from other tribunals or courts, you cannot file appeal under Article 132 of the Constitution of India. Apart from that, if we read Article 132(1), it says, an appeal shall lie to the Supreme Court. Word is shall. An appeal shall lie to the Supreme Court from any judgment, decree, or final order. Only three things. We must remember this. It should be a judgment or a decree or a final order, not any other thing, not determination. Judgment, decree, of a high court in the territory of India, whether in civil or whether in civil, criminal, or other proceeding. So I'll repeat again. So appeal shall lie from against any judgment, decree, or final order of High Court in civil, criminal, or other proceeding, if the High Court certifies under Article 134A, it means a certificate under Article 134A is involved, is necessary, that the case involves a substantial question of law as to the interpretation of the Constitution. So this jurisdiction has been, I will repeat it, this jurisdiction has been given to Supreme Court only against the judgment, decree, and final order of a High Court, whether in civil, criminal, or other proceeding. So void in terms of whether it is civil, criminal, or other proceeding. In this case, the certificate by a High Court under Article 134 is required, and the certificate must say that it involves a substantial question of law to the interpretation of Constitution of India. Otherwise, not. So now the question arises: certain judgments with regard to the appellate jurisdiction under Article 32. Supreme Court has held that an appeal under Article 132 would not lie against any interlocutory order. And then a substantial question of law to the interpretation of Constitution of India is required. But a question was asked that was raised in Election Commission of India versus Venkata Saka Subbarao. This is 1953 judgment, that whether an appeal lies from the decision of a single judge also. And Supreme Court answered it in affirmative. It said that yes, appeal under Article 132 can lie against a judgment, decree, or final order of the High Court. So the question obviously is that the question relates, it should be, the certificate should be, not should be, certificate must be that it involves the substantial question of law to the interpretation of the Constitution of India. When we see Article 133 of the Constitution of India, there is a difference, as I said, between Article 132 and Article 133. It says, Article 133, appellate jurisdiction of the Supreme Court in appeals from High Courts in regard to civil matters. So, in this case, appeal lies only in cases of civil matters. So, if criminal matter, in that case, no. 133 can't be invoked. And the other relevant, like 133(1), says that an appeal lies to the Supreme Court from any judgment, decree, or final order in civil proceeding of a high court in the territory of India. The requisites are 133 1A says that the case involves a substantial question of law of general importance. So now there are distinguishing features. First thing is civil matter. Second thing, from because questions are asked as to what is the distinction between Article 132 and 133 of the Constitution of India. In that case, we should write that the distinctions are like 133 can be invoked in civil cases only, and second, in 132 it says that the certificate should be a substantial question of law to the interpretation of Constitution of India. But here, the the certificate has to be given that the case involves a substantial question of law of general importance. So constitutional importance, now here general importance. And 133 1B says that in the opinion of the High Court, the said question needs to be decided by Supreme Court. So, along with the certificate, the opinion of High Court is must. 133 2 says uh, 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 133 3 says, notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree, or final order of one judge of High Court. So here it specifically bars that order passed by a single judge does not, or the judgment, decree, or order passed by a single judge of a high court. In that case, you cannot invoke Article 133 of the Constitution of India. Now, I think so far as today's class is concerned, we have covered the original jurisdiction of the Supreme Court and the appellate jurisdiction of appellate jurisdiction provided by the Constitution, the Supreme Court, Article 132 and Article 133. Now, in the next class, we will cover Article 134 in the certificate, Article 134A, then Article 136, and about the statutory appeals. And then we'll discuss about the advisory jurisdiction and the other jurisdiction also. Thank you very much. Thank
So,
you.
Mr. Bharat Singh wants to raise some query or question.
Yes. Yes, Mr. Singh. You are not audible.
I guess now Miss Bhavna Kapoor is there. Yes, Bhavna.
Sir, am I audible?
Yes, you are audible. Yes, please tell me.
Two questions. One, this question has been asked time and again in different lectures. What is an ideal length for giving an answer in the examination? Of course, we've been hearing this time and again that as you're mentioning your point, the
Yes.
is all satisfactory. But when a question is asked which carries, say, 10 marks or say 20 marks, we need to
Yes.
find something which is beyond the basic principles involved. So,
Yes.
it is like 10 marks or 20 marks, sir. What would you advise to be the ideal length for the answer?
See, this is a problem which I also faced. I tell you, when you start writing an answer, then you keep writing it, and then what happens that for other questions you are not left with the time. So you'll have to judiciously decide about each questions also, as to how much time you'll have to give. This is very, very important. So see, what happens that now we are accustomed to like typing in computer. We read it, we see the judgment online, and then we type it or we give dictation to our colleagues or the steno, whatever it is. So we this practice of writing also we forget. So I would advise, now I don't know, some mock test is going on. The Supreme Court may change its the pattern and how to the write the examination. But I would advise you till this mock thing and all, like till this new system comes into play. So you should try to write also. And you have asked a very, very important question, because what happens that a question very well, and you give your time 30 minutes, 45 minutes, and no time is left for other question. So you'll have to decide it judiciously. You'll have to practice it also before appearing in examination. You must practice, and you must see. I would advise you to try to solve the earlier previous question papers also. So it would give you some insight as to how to appear. But uh, I would suggest that you should not leave a single question. Whatever is there, you should answer it. Should be very precise, very brief, to the point, and when you get the time, then you give all those judgments, whatever you know.
Thank you, sir.
Now we can, I think, sir, wrap this session
Yes,
for
Mr.
today.
Rajan.
Okay, Mr. Rajan.
Yes, Mr. Rajan.
Yes, sir, I am audible.
Yes, yes, yes. Please tell me.
Sir, your session is very good, and I asked to some question related to how to give the answer for the your examination. It means elaborating answer, yeah, small answer. कैसे
See,
देना है?
I think you should be brief. Like, you should be to the point. If you know,
It
if
means the important point answered.
yes, yes, you should try to cover. Like when I said, because if you go on writing about Article 32, it is endless. There are
Yes,
so many cases and so many instances. As I told you, that we all know that there are 5 types of writs, and in that
yes,
case, P.J. Thomas case, Supreme Court issued a declaration.
yes,
So there are so many things, like if you and you should be brief. Like when you are asked about the what is the difference between Article 132 and 133, in that case you should just bring out the difference, that there should be like judgment, decree, and final order by high court. The important point is, but the important point is, it must involve a question of law to the interpretation of the constitution, and 133 question of law of general public importance. Like single judge also, it can be entertained. In that case, no single judge. And second, like as I said, that criminal or any matter 132 can be applied here in civil matter. So you'll have to be, very precise also, to the point.
okay, okay, sir. Thank you, sir.
Okay. Okay, Suti, ठीक है?
Sure, sir.
Yeah.
Thank you, everyone.
Thank you.
Okay, sir. Thank you again.